Good morning, Your Honor. May it please the Court. Joseph Lee, Lee Law Group, on behalf of the appellant Michael Farrington. We respectfully reserve 7 minutes for rebuttal.
I'll give you 5.
I'm sorry, Your Honor?
I'll give you 5.
5 will be fine, Your Honor.
Thank you.
For any matters not discussed herein, we would rely on our briefing and the authority therein. There are 4 issues presented on appeal. There's only one that I wish to address for the Court's consideration and argument. Issue 4, whether the trial court abuses discretion in denying the motion for continuance, which was made on the second day of trial, Thursday, November 2nd, 2017. The lower proceeding involved a quiet title to determine the boundary lines with regard to disputed property in Sarasota County. It was a bench trial, as to be expected given the subject matter. In terms of a brief synopsis of the facts relevant to the argument today, on June 23rd, 2017, a pretrial order was entered. There was general language in there in terms of a general disfavorment against continuance, and with regard to expert witnesses and the availability for trial, that a video or something or deposition be taken in the event or once it becomes known that the expert witness was not available. The trial set the entire week of October 30th through November 3rd, 2017 for the trial proceedings. Trial proper began on November 1st, 2017, which was a Wednesday. During the course of that, the expert for the plaintiff, Mr. Dudziak, Mr. Strayer being the expert, testified in favor of his client with regard to the boundary line survey. Mr. Farrington, pro se, asked that his expert, Mr. Serrato, be taken out of turn. Mr. Serrato was present on November 1st. The counsel for Mr. Dudziak objected. The motion was denied. Mr. Farrington then testified in Mr. Dudziak's case in chief. On November 2nd, 2017, which was a Thursday, Mr. Farrington requested continuance based on 2 reasons. The first being that Mr. Serrato was unexpectedly unavailable due to an emergency environmental hearing in Tampa, and secondly, that Mr. Farrington was not feeling well. Counsel for Mr. Dudziak objected based on the pretrial order and stated a preference that the case continue and that it should be resolved as quickly as possible. There were some arguments with regard to alleged discovery violations, but then the trial court, having no choice other than by virtue of its denial of the motion for continuance and having only the evidence presented on behalf of Mr. Dudziak, specifically the survey evidence by his expert, Mr. Strayer, directed a verdict in favor of Mr. Dudziak. With regard to the issue that I wish to argue, whether the trial court abused its discretion in denying the motion for continuance, there are 2 lines of cases relevant to it. The first is with regard to continuance. Second is with regard to the exclusion of witnesses.
Can I ask you a question? I understand he was pro se below.
Yes, Your Honor.
But I have a recollection that the judge was very solicitous of his situation and said, take all the time you want. If you want to take a break, we'll take a break, etc. And I recall that your client, thank you, Judge, I'll do the best I can. So does it raise a preservation issue?
I don't believe it does, Your Honor, because with regard to the issue specifically before it, and that was actually during, I believe what the court is referencing is more on the second day of trial, in terms of when he had expressed that he wasn't feeling well. So the accommodations that the lower court was making was primarily with regard to trying to accommodate his health issues.
What was the basis of, did your client, proceeding pro se on the first day of trial, explain to the trial court the reason why he wanted to take that expert out of turn?
There was no proffer given in terms of the explanation.
So in other words, he didn't bring to the trial court's attention that despite it being noticed as a 1-week trial, that the person would be unavailable the next day. He only brought that to the trial judge's attention on that day, the second day of trial. Is that correct?
On that day, the context suggests that he didn't know in terms of the unavailability of his expert, Mr. Serrato, until the next morning.
So he just asked it to be taken out of turn?
Yes, Your Honor. And
in your position is the client just asked for no reason?
No, not for no reason. The context of the transcript and a review of the transcript establishes, maybe because he was a pro se, that he was trying to immediately rebut the survey information given by the expert for Mr. Dudziak, for Mr. Strayer. So he was trying to take it out of turn, addressing each issue as they occurred. And a review of the transcript more generally establishes that's basically what he was trying to do through the trial.
So it's fair to assume that he was not aware that his expert was going to be unavailable.
Yes, Your Honor.
Okay.
In reviewing both of those lines of cases together, dealing with the continuance and the exclusion of a witness, both lines independently and in a spectrum overlapping, we would contend that the trial court erred in failing to continue the trial. First, with regard to the unavailability of the witness, we would reference Fisher v. Perez, cited in our brief. The standard of review is abuse of discretion. We recognize that. However, in the factors given by Fisher, we would contend that a sufficient showing has been made as to all of those, that the trial should have been continued. First, prior due diligence to obtain the witness's presence. Mr. Sarasota was clearly present the prior day before. And in terms of a review of the transcript, there doesn't seem to be any dispute that he was unavailable unexpectedly on November 2nd. In the answer brief, Mr. Dudziak's counsel argues that it's speculation whether Mr. Farrington knew Mr. Sarasota would be unavailable or not. However, in looking at the other factors, that issue isn't the primary focus. It's clearly the witness was available the day before on November 1st, which was the first day of trial. And if anything, the fact that he moved to take the testimony out of turn in the context of trying to address the expert evidence presented by Mr. Strayer shows that it was largely unexpected.
Well, how would that rise to an abuse of discretion? There's a request to have the witness testify out of order, and there's no explanation as to why. And I understand your client's proceeding pro se, but I guess the trial judge just wants to run this train as you would a normal trial.
Well, and even
that can't be an abuse of discretion, can it?
well, in looking at all of the factors present, yes, we would contend that it was an abuse of discretion. With regard to the second factor, substantially favored testimony would have been forthcoming. The effective proffer, and for that we would reference the transcript as 67 to 70, 132 to 47, and 121. The effective proffer of the evidence that Mr. Sarasota would have presented was that he was going to present survey-related evidence, that Mr. Strayer's survey was defective and differed from one in 1986, and that Sarasota was a, quote, survey witness, end quote. So in terms of the necessity of the evidence, the context of this case, especially considering it was a directed verdict based on one side presenting its case, is very well established. With regard to the third factor, the witness was available previously and generally and willing to testify previously or generally. In the answer brief, counsel for Mr. Dudziak contends that no, that's not shown because he was unavailable, because the expert, Mr. Sarasota, was unavailable because he was at a hearing in Tampa. However, that's a misreading of the law. This factor looks to in terms of the general or previous availability of the witness and his willingness to testify generally or previously. There's no question he wasn't available that day. Otherwise, this factor becomes meaningless.
Part of the reason why in the case that you cited to be your principal one, it was that the witness who was unavailable in the Fisher case, there was proffer arguments made to the trial court explaining that not only did I call the night before to assure that the witness was going to be there, I talked to him a week ago. I let him know that he needed to earmark the entire week. I let him know, what do we have on this record to for us to determine that no other reasonable judge would have done this. In other words, what was the proffer given by and the pro se litigant here of due diligence that was made to secure his attendance? And that's kind of where I was going with the question as to why he asked for going out of turn.
In responding to that, let me ask both generally and specifically. In terms of general due diligence, he was there the day before, and he was willing to testify, and maybe with or without a legal basis. Mr. Farrington actually asked to take his testimony out of turn. So there's obviously the good faith is sort of satisfied. With regard to his unexpected absence the next day, on November 2nd, the proffer was that he was unexpectedly unavailable due to an emergency environmental hearing in Tampa. Now, even with regard to that, there were some attempts to try to find out if he would have been available that day. A review of the transcript, indicates and establishes that Mr. Farrington attempted to try to call him, didn't have much success with that, and finally came to the conclusion that he wasn't going to be able to get in touch with him to determine his availability for that day, or even for the next day, which was also slated for trial.
Is there record evidence that the expert was under subpoena?
There's no evidence indicating one way or another, Your Honor.
Is that part of diligence?
I'm sorry?
Isn't that part of due diligence?
It can be in terms of fact-specific, but if the witness...
We are fact-specific here.
With regard to, and this one we would contend no, because even assuming that there was no subpoena, then this was a situation where he was an expert witness retained by Mr. Farrington. He was there the day before. There was no reasonable expectation, except for something unexpected, that he would not have been available for the second day of trial. And with regard to the most important prong of all established under Fisher, looking in terms of what the material prejudice would be, this case is obvious, and especially if you weigh them. With regard to the prejudice that Mr. Farrington suffered, the trial court had no choice but to direct a verdict after presentation of only half the case. In comparing that with the prejudice that was suffered or claimed to have been suffered by Mr. Dudziak, the only justification in terms of their argument against the motion for continuance was that there was a general disfavorment against continuance in the pretrial order and an expressed desire, we just want to get this done. In weighing those considerations, it is manifestly clear, both as a matter of law and as a matter of fact, that the weighing of those considerations weighs in favor of a trial continued so that there could be a disposition on the merits. Now, with regard to Fisher, which we rely heavily on, and not only in terms of the factors, but in terms of general guidance, we recognize that because this is abuse of discretion, it's going to be case-specific. However, in that case, the appellate court held that the trial court abused its discretion, denying the continuance where the expert witness was unexpectedly unavailable, in that case due to medical reasons, and where the witness was critical. And
due diligence was done and proven as set forth as a basis for all the things that were done by the witness denied of by the side denied of that expert testimony to secure that the individual would be there.
yes, and we would contend, as I just argued a few moments ago, that due diligence was satisfied in this case as well.
Was there any indication that the expert was going to be available on a day 3?
There was no indication, and quite frankly, the issue became moot, because once Mr. Farrington made the motion for continuance, and the only argument presented by the opposing side, counsel for Mr. Dudziak, was, no, Judge, we object because of the pretrial order and because we want to wrap it up. So at that point, it went straight into a directed verdict. We would also reference LaView versus Travelers Insurance, similar type of reasoning cited by authored by the 4th DCA and cited in our briefing, that the trial court abused its discretion in failing to continue where the expert was not available at the time, estimated by counsel, and was the treating physician in a personal injury suit. Now, we would, and I'm not going to present argument with regard to Mr. Farrington's health issues. I think the focus here has to be with regard to the exclusion of his only expert, or the critical expert, creating a dispute in the evidence. Now, in moving to the next line of cases dealing with the exclusion of witnesses, we would reference first Gaspar Passages versus Racetrack, authored by this court in 2018. This is the critical case in terms of there has to be some kind of balancing of the prejudice. The prejudice analysis and weighing the importance of a witness to the proffering party as compared to the prejudice of the objecting party. In this case, there's no analysis done at all. And on that basis alone, we would contend that reversal and remand is proper. The trial court simply excluded the testimony and denied the motion for continuance based on the counsel's desire to proceed with the case. That was it. There was no consideration in terms of any substantive prejudice to either side, although the context establishes without question what the substantive prejudice would have been and in fact was for Mr. Farrington. Addressing that particular procedural issue, in terms of the substance and on the merits, as I just stated, for Mr. Farrington, the testimony of Mr. Serrato was critical. It either would have impeached or disputed or challenged the survey information provided by Mr. Dudziak's expert, Mr. Strayer, or possibly could have been conflicting evidence with regard to the survey. In either case, with Mr. Strayer's evidence standing alone, there was no choice but a directed verdict. With regard to the...
You are into your rebuttal time. You're a little bit over 15 minutes, but you can use your time as you wish. I just wanted to give you the heads up.
Okay, thank you. One more moment then, and we'll go into the rebuttal. With regard to the prejudice that was suffered by Mr. Dudziak, again, violation of a supposed pretrial order's disfavorment against continuance and a desire to proceed with trial. We would also reference Binger versus King Pest Control, cited in our brief. Although the trial court has discretion to exclude a witness who is not disclosed in accordance with the pretrial order, so even if there's a procedural defect, it should not do so blindly, but instead be guided by the determination of prejudice. So accepting any further questions in the first presentation, we would ask for an affirmance subject to the rebuttal arguments.
Thank you, Mr. Lee. We'll give you about 4 minutes on your rebuttal, okay?
Thank you, Your Honor.
Thank you.
Good morning. May it please the court, Cheryl Edwards for the appellee, Stephen Dudziak. Your Honors, this case is not about an abuse of discretion by the trial court. This case is not about an error of law committed by the trial court. This case is about an appellant who failed to retain an attorney, who failed to abide by the rules of civil procedure and failed to introduce any evidence or testimony to refute the allegations of the complaint or to rebut plaintiff's evidence. Plain and simple, that's what this case is about. Although counsel restricted his argument only to the fourth point on appeal, I would like to address 2 other points briefly that were briefed by both parties. It appears that we are in agreement on the standard of review for this court for points 2 through 4, that's an abuse of discretion. Counsel argues that point 1 is subject to a de novo review standard, so I'd like to address that. In the briefing, counsel argues that point 1 is a discovery violation. A careful review of the record would reflect there's no such discovery violation. The issue giving rise to that argument essentially was one where the appellant made a one-line request in a request for production of documents that was objected to under many arguments. Those objections were never set for hearing before the trial court. There were no discovery sanctions that were issued by the trial court, which again would distinguish the cases cited by the appellant in its brief on that point, essentially where those cases indeed were discovery violations. They were, for example, PNB Paribas is a case cited in appellant's brief where the court imposed a $50,000 discovery sanction without an evidentiary hearing. That was found to be subject to a de novo review standard. Under the Dabbs case, it was the discovery violation was found to be a Richardson hearing in a criminal case. Again, distinguishable on facts. It has nothing to do with the facts as we have before us today. So I did want to bring that to the court's attention. With respect to the third argument on appeal, again, not argued by counsel today, but I do want to bring something to the court's attention, something that I realized in preparation for today's argument, which I missed while I was preparing my brief. Point 3 is that the appellant, that the trial court erred in prohibiting Farrington from introducing public records and plats into evidence in cross-examining Dudziak's expert witness surveyor, Mr. Strayer, who he spoke about earlier. if you do a careful review of the trial transcript, which I did, and I was counsel at the trial level, I looked at Mr. Farrington's cross-examination of Mr. Dudziak, and he never once actually tries to introduce public records or plats, documents in the public records, into evidence. At page 135 of the trial transcript, he attempts to introduce a letter from the building department. That was excluded as hearsay. At page 138, Mr. Farrington asks Mr. Dudziak, who is on the stand, about a plat previously done by Mr. Britt. Well, there's no plat prepared by Mr. Britt. The reference by a pro se litigant to the plat is actually one of a survey, a different survey prepared by a different surveyor who was not called as a witness, was not listed as a witness in the case. Page 140, Mr. Farrington attempts to ask Mr. Dudziak about a survey prepared by his own surveyor, prepared by Lynn. And actually, the transcript refers to him as Lynn, L-Y-N-N. The actual survey is prepared by somebody by the name of Lint, L-I-N-D-T. Those are the only attempts by Mr. Farrington at trial to introduce any documents into evidence. Again, there were no attempts to introduce public records or things where the court might have been able to take judicial notice of public records upon a correct request. So I didn't want to bring that.
It just seems like you're making the other side's case, though, to show and emphasize the prejudice of the trial court not granting continuance for the evidence that he did intend to put on, which was his own expert's testimony to rebut that of the plaintiff. I mean, it's like you're underscoring the importance of this by going forth and saying, you know, well, he didn't attempt to do this, he didn't attempt to do that, he was a pro se litigant, it's his fault for not getting a lawyer. So let's move to the issue that he did discuss and explain, you know,
Absolutely.
that there was an ardent objection for a continuance on the morning of, when the explanation was the person was called away to go in front of a municipal board.
Well, one of the reasons I bring up the attempts by Mr. Farrington to cross-examine Mr. Dudziak is each of those documents that he was attempting to cross-examine him on essentially were outside of the scope. So, I mean, he had an opportunity to attempt to introduce those things in his case in chief, but he never put on a case in chief. So, again...
He tried to, right?
No, he did not.
No.
A careful review of the transcript shows that the court asked him if he was going to testify, told him he had the right to testify, and he said, I have nothing to testify to. That's clear in the transcript.
So his expert testimony would not have been in the case of chief?
Mr. Farrington's expert testimony would not have been in his case in chief? Well, I understand your point that as far as...
This is all he had.
We don't know...
As a pro se litigant, and there was an objection made to the trial judge that, listen, my witness took off here. He went to an emergency thing. I've tried to get in touch with him. I object because the pretrial order contemplates general availability, and they're frowned upon.
Well, to address the point that was made by counsel as far as the proffer that actually was not made on day one when Mr. Farrington, the appellant, tried to have his expert testify out of turn, he simply made the request without any proffer whatsoever, not the fact that, well, you know, he's got a busy schedule and we're not sure he can come back tomorrow. There was no proffer whatsoever.
Because maybe there wasn't an idea or suggestion that he wouldn't be available the next day.
Who knows? There's no evidence of that, and as the appellant certainly...
As Chief Judge LaRose said, then it's fair to say then that he was just doing it the way he had throughout the trial, just go, you know, tit for tat sort of situation.
We don't know. That's complete supposition. We don't know what he was thinking when he was doing that, whether or not it was tit for tat or whether it was essentially just the complete unfamiliarity of protocols of presentation of evidence. We absolutely do not know that answer. Going to point 4.
And I agree with you on that.
Thank you, Your Honor. Going to point 4, which is the argument made by counsel that the trial court erred in denying the motion for continuance. First of all, from a practical standpoint, how does a diligent litigant not address an expert's availability for the entire trial period? It's incumbent on a litigant, whether they're pro se or represented by counsel, to abide by the rules, to abide by the prior orders of the
How
court.
do you account for an emergency? What makes a person, if the same thing would have happened to your expert the day before, and it was denied, you'd be making the same arguments.
Well, maybe I would have done something different. I possibly would have gotten an affidavit or some sort of evidence. A very careful review of the trial transcript, the appellant was never sworn, not once. He was not sworn as a witness, so he was providing argument the entire time during trial. So, it certainly is not lost on me, and I hope it's not lost on the court, that the appellant did file a motion for new trial, motion for reconsideration. There was no evidence in support of any of the arguments that they are now making. I mean, if he was indeed, did he have an emergency? Well, let's see it. Let's see the evidence that he was at this other emergency environmental hearing. Is there a transcript? Is there a court appearance record? Something to show us that that really is what happened. There's nothing. And again, Mr. Farrington, the appellant, he was not sworn at the time he was making that argument. So we agree with counsel that the Fisher versus Perez case is instructive on the necessity of the appellant to seek a continuance for the unavailability of the expert witness. Prior due diligence to obtain the witness's presence, the substantial favorable testimony would have been forthcoming, that the witness was available and willing to testify, and that the denial of the continuance would cause material prejudice. Your Honor, you asked the right question. Did you subpoena your expert? And the answer is no. The record reflects that he did not subpoena his expert, and that, of course, would be required by the the Garrison case, which is, of course, a prior case of this court. He also fails to show that substantially favorable testimony would have been forthcoming from Mr. Serrato. Other than the one-line description in the witness and exhibit list of what Mr. Serrato was going to testify to, we have no idea what he was going to testify to. None of the exhibits that Mr. Farrington was seeking to introduce were surveys prepared by this individual. He never took his deposition. There was no way for us to know, or the trial court to know, exactly what Mr. Serrato was going to testify to. I think he is disclosed on the witness list as a civil engineer, not as a surveyor. So it was completely unknown, either to myself as opposing counsel or to the trial court, what Mr. Serrato's testimony was going to be. Certainly an issue that does not meet that second prong of the Fisher test. It is clear that Mr. Serrato was not available and willing to testify. However, again, I think we've addressed that with respect to the fact that he's an environmental hearing, again, unsworn and unverified statements by Mr. Farrington. And then finally, he failed to show material prejudice as a result of his expert's failure to appear for testimony. Again, we don't know what that testimony would have been, so how can he show what the material prejudice would be? Other than that, I really don't have anything further. If the court has any questions.
Thank you, Ms. Edwards.
Thank you, sir.
Mr. Lee?
May it please the court. In rebuttal, with regard to any arguments outside of issue 4 and notwithstanding any unintended violation of procedure, we would just stand on our briefing. We would also contend, as pointed out by the panel, that indirectly that may have actually shown some of the prejudice with regard to the elements with regard to the continuance. Now, with regard to some of the points brought up, first we would contend the law is manifestly clear that that the law favors a disposition on the merits. That was never done in this case. In addition to that, and for there we would have a reference against Gaspar and Binger. With regard to some of the points that were brought up by the appellee, to some degree they're putting the cart before the horse. First of all, in terms of Mr. Farrington not being sworn in, this is where they're sort of picking and choosing in terms of, well, he's pro se, it's his own fault, or he's also, but at the same time, he should have been sworn in. Counsel would not have had to have been sworn in to make the proffer in terms of the unavailability of the witness. But even more fundamental than that, in terms of, for example, the arguments made that there was no evidence presented of unavailability, for example, that there was an actual environmental hearing in Tampa, or whether Mr. Serrato was available the next day. That truly is putting the cart before the horse, because at that point, the case was over. He made a motion for continuance. Counsel said, no, I don't want to continue it because it violates the pretrial order. Court, okay, directed verdict. So a lot of the considerations which may come in after the fact, at the time in terms of the progression of the event, never had the opportunity to become ripe or fully developed. This is an example of form over substance, and referencing especially Gaspar, where there has to be a procedural safeguard to ensure that there is substantive prejudice, a weighing of the prejudice. In this case, there's no question in terms of how that weighing factors. Regardless of whether Mr. Farrington was pro se or represented by counsel, the motion for continuance was denied, and that effectively prevented him from presenting the case. The only prejudice, which is not substantive, at most is procedural, that Mr. Dudziak, or his counsel, is that they wish to proceed with trial. And although there is a line of cases that says pro se litigants have to protect their own rights, as a former Assistant Attorney General, we also know in terms of the line of cases that especially in post-conviction proceedings, pro se litigants have to be given some degree of leeway because they're not legally trained. And in this particular case, where the pro se litigant was prevented from presenting his case, and there wasn't even any opportunity for the full development of the argument or the weighing of prejudice, we would contend that there was an abuse of discretion. So accepting any questions from this panel, we would respectfully ask this court to reverse and remand for there to be a trial so that there could be a full resolution on the merits. Thank you.
Thank you, Mr. Lee. Thank you both. We are going